The second part of the morning will be devoted to a second lecture, again related to the prediction of migrant movements and the use of artificial intelligence for that purpose. The speaker is Graziella Romeo. She is Associate Professor of Comparative Constitutional Law at Bocconi University, where she is also STEAM Director of the desk Democracy, Solidarity and Governance within the Bocconi Lab for European Studies. Please, attention, please. She's been visiting in several universities abroad, including Fordham University School of Law, London School of Economics, Washington University in St. Louis, etc. Her main research interests concern constitutional theory, in particular in relation to constitutional reasoning and fundamental rights, including migrants' rights. And with specific regard to migration, she's studying the use of algorithm in public decision-making. Thank you very much, Graziella, for being here with us. I leave you the floor. We have to close at 1:10, 1:15 maximum. So the floor is yours. Thank you.
Thank you very much, and thanks for this kind invitation. And I'm sorry for not being able to be with you in person due to unforeseen reasons. First of all, let me clarify what we are going to do today. I know that you have already explored the use of artificial intelligence tools in migration studies. What I want to suggest today is to discuss the use of artificial intelligence-driven predictions from a legal viewpoint, which means not only that I will try to draw your attention on the legal implications of using such tools, but also that I will try to understand what are the problems that lawyers face when they have to confront or to address those the studies that social scientists have done on predictions of migration. So what you will see now is how a lawyer can approach this topic with his or her own tools, and trying to understand what is exactly, what are the implications of artificial intelligence in this context. And on such a basis, I will then suggest a regulatory framework that is aware of the fundamental rights implications of artificial intelligence. As you will see, I will at some point shift the focus from the rights of migrants to the general problem of the political risk of artificial intelligence-driven predictions, also for citizens. They are supposed to receive and accept migrants in their territory. So let's start from what exactly are we talking about when we discuss artificial intelligence-driven predictions in this context. First of all, in the literature on artificial intelligence and predictions, you will always find some reference to the fact that migration is largely unpredictable. In what sense? In what sense that even social scientists, and I am sure that Professor Carammia already stressed this point, agree that there may be different drivers of migration. And those drivers may not always be encapsulated by a specific tool. So you may have an artificial intelligence tool that is able to understand or to process certain drivers, but misses others. And why is that? Because the flaws of human beings has always been quite difficult to capture in a model. Now, we also have to be aware of the fact that forecasting migrants' arrival is not anything but a new trend. The link that you see in this slide that I will then circulate among you is a website of the US government where you can find a study dated 1988 on forecasting migration, which was based on largely unsophisticated tools compared to today. But what I think is interesting is that government always felt the need to understand the migratory flows for many reasons, not only for protectionist reasons, but sometimes to be able to address, to face the consequences of migration. So predictions are something different than forecasting. Predictions have something to do with estimating the outcomes of unseen data, which means either data that are test data or data that we don't yet know with precision. And when we discuss artificial intelligence in the context of migration, most of the time we are talking about tools that use both forecasting and predictions. Forecasting means that those tools use past data to understand trends, and while predictions means that they are trying to estimate something that is unknown, still unseen. Now, what predictions or forecasting, we will use both terms interchangeably, tell us? They can tell us, of course, the number of arrivals from certain destinations in a certain amount of time, but also the direct or indirect factors that conditioned or trigger migration. And as you will see, it's particularly complicated from a legal perspective. This is precisely one of the elements that is legally difficult to face. Now, what is the reality now of the use of forecasting or predictive algorithms? I am sure you have discussed the technicalities with Professor Carammia. What I want to discuss with you is what a lawyer, what are the information a lawyer can access to. So from a legal viewpoint, when you try to understand the actual use of artificial intelligence by public authorities, you will be able to access some data. For example, the use of algorithm by the UN Population Study Division. But those are especially artificial intelligence tools that do forecasting of flows. One of the most known is Jetson. I don't know if you have discussed this with Professor Carammia, but it's a tool funded by the UN High Commissioner for Refugees. And it's a very interesting tool because it combines quantitative data, quantitative analysis of data with qualitative analysis, which means with interviews that scientists do, social scientists do with migrants to understand their life story, to understand what is the reason why they left their country, what are their expectations, and so on and so forth. So Jetson is considered to be a quite balanced tool for migration prediction. At the EU level, we know for sure that the EU authorities use EatFlows. There is a artificial intelligence tool elaborated within a Horizon 2020 research project. So it's funded by the European Union. And also the early warning and preparedness system, which is the system you have discussed with Professor Carammia. We also know that the EU authorities claim that they do not use iBorder, which is an artificial intelligence tool that is supposed to be able to identify migrants' emotion. We know for sure that the European Union claims that they do not use it, and as you will see in a moment, we will discuss why this is the case. The link that you see again on these slides is a link to a detailed assessment of the European Parliament on the use of those artificial intelligence tools within the European Union by the European Union institutions. Outside the European Union and outside the international context, we also know that states use certain tools. One of the states that has been more transparent on that is Denmark. So we know that the Danish Minister of Foreign Affairs uses Foresight, which is a tool comparable to the ones used by the European Union. What is interesting about those tools, in particular Foresight and the one that you have discussed with Professor Carammia, is that those tools claim to be transparent in the sense that the algorithm is transparent, and also it's replicable. So it's possible to use it to replicate, so to check the results. And again, this is another important element on which we come back in a moment, the replicability, the possibility to replicate the results, to check whether the results were correct or not. Australia, Canada, and the United States, they also use artificial intelligence-driven predictions. Australia, for example, uses those tools to understand countries' safety conditions, which are relevant for asylum claims. So they try to understand whether certain countries are safe, so that in case of expulsion or denial of asylum, the migrant will not face consequences deriving from the expulsion. So this is what we know. This is what we are able to understand ex post. These are some of those tools are also, they have websites, so you can check, you can try to understand how they work. And so this is the realm of the known from a legal perspective. From a legal perspective, what is important, I think, if you are not a specialist of artificial intelligence tools, if you are not a social scientist who actually contribute to building those tools, is the question asked and the answer you get from the artificial intelligence. The ability to understand the question and to understand the answer is crucial to the use that you can have, you can perform of those tools. Professor Carammia at the end of the lecture told you knowledge per se is not the issue. The issue is the use of knowledge. I very much agree with that statement. And what we are discussing now is the use of the knowledge. We can approach, understand partially how the knowledge is produced, but the point is also the use of that knowledge. Now, the use of that knowledge has something to do with the extent to which we understand the information coming from artificial intelligence. I give you an example. This is a UN population division study that you can see in this slide that has been discussed in a paper in 2020. I can give you the details of the paper after the class. So in this UN population division study, the UN has estimated that in order to ensure what it's called the support ratio, meaning the percentage of workers, of active workers per retiree, Germany would need more than 3 million immigrants per year over a period of time from 1995 to 2000. So this is an algorithm, okay? So this is a calculation that is made through an algorithm. But this is not a prediction. This is a study that is done to answer a question: how much immigration do we need in a certain state? Now, the answer is different, and if the question asked to the algorithm is how many immigrants does Germany need to maintain constant the number of workers regardless their ratio with retirees. So you can see here that if we just get to the number 3 million versus 460,000 people, we do not actually understand what exactly is the question that has been asked to the algorithm. This is a very easy algorithm to understand and to discuss, because it doesn't use past data, it doesn't go into forecasting, it's just assessing a number. But the problems get much more complicated when we discuss the forecasting algorithm or the prediction algorithm, because in those cases you will have the result, you will have the numbers, you will have the 3 millions or the 460,000, and you may not be able to understand what is the different question that has been asked to the algorithm, and why then we come up with those numbers. So what it means that to understand the question that is asked to the algorithm and to understand the answer at the same time, we need to be clear on certain variables. First of all, what are we talking about when we say migration? Are we talking about the net value of people that enter the country, meaning considering also those who leave the country? So migration in this sense, which is the term that is used constantly in legal document in Europe, is a net value, is the true flow of people, the people that enter, considering also the people that have left the country. Or we may talk about immigration, which is the overall number of people that enter the country without considering those who have left the country. So when we discuss a prediction or a forecasting made by an algorithm, we should know whether we are discussing migration or immigration, because from a legal viewpoint, this can make a difference. Second element is what kind of data are fed into the algorithm. Are those open source data, for example, demographic data, or data that are currently studied or used by national authorities that we can verify or that at least pretend to be true, to be actually openly subjected to verification? Or are we talking of data that are collected by a private entity? And again, those data are fully transparent, are replicable, can be studied by other social scientists that can check the results or not. So these are all elements that are relevant to understand what exactly are we asking toward the artificial intelligence and what is the reply that we are getting from the artificial intelligence. And the other element that I think is very important is the internal factors that in a certain state can driven migratory flows, what you have discussed with Professor Carammia as the pull factors in those studies. Those are all elements that we need to take into consideration when we discuss the legal framework of artificial intelligence in the context of migration. Now that we have, I hope, clarified this point, let's move to the legal implications. What are the arguments so far supporting the need for predictions? We can identify at least 3 arguments. Some of those arguments are available in public discussions on artificial intelligence in the context of migration. Some of those arguments have been specifically addressed by those who are using the artificial intelligence tools. For example, if you go on the website of itflows, you will see that they openly discuss some of those arguments. First of all, predictions may be relevant to help public authorities to organize the reception of migrants. So it's a matter of efficiency, it's a matter of quality of the reception. It's a matter also of compliance of reception conditions to what is required by the EU. And the compliance will be higher if public authorities are in the position to know in advance what are the flows expected. Second argument, predictions will help preventing social tensions, because if we know that in a certain territory there are tensions related to the arrival of migrants, then we can understand that that territory will be particularly hit by migration, and so we may need to be particularly careful in that specific territory, and we may need to implement certain change or to implement certain policy in that territory to prevent social tensions. And third argument for prediction, understanding demographic trends. We may need to predict migration to understand, for example, the impact on infrastructure, the impact on welfare, on the welfare state, because of course more migrants mean also more engagement of the welfare system. Those arguments supporting the need for predictions are all valid, but as you will see in a moment, they are also they also meet counter arguments that suggest a different approach. What is now the current regulatory framework given the existence of those tools, and given the arguments that are publicly put forward to justify the use of those tools? Well, we know that those tools are used by EU institutions, by state, but the use of those tools does not need a special authorization. In what sense? In the sense that there is no principle in international law that requires state to pass specific legislation to authorize the use of artificial intelligence in the context of migration. This is a way of saying that the instrument is there, the instrument exists, and since the instrument exists, it can be used. We know it is used, but there is no need for a parliament to pass a law saying you can use this instrument in this specific context, which is quite problematic when it comes to the use of tools that have impact not only on fundamental rights, individuals' fundamental rights, but also a general impact on a civil society, on a political community as a whole. This is a quite interesting aspect, and the current legal framework does not fully address the problem. You know that we have a EU regulation which is called the GDPR, which concerns the protection of data, and this piece of legislation is not conclusive in this respect, in the sense that we have an Article 22 that says that people have the right to challenge automated decisions made on them. We know that they have the right to challenge those decisions. We know that they have the right not to be subjected to those decisions in certain contexts. But this article has not been interpreted so far as to demand that law should authorize the resort to automated decision in any given circumstances. In a way, such a logic has been replicated by the European Union Artificial Intelligence Act, that, as you may know, is currently pending before the EU institution, but about to be adopted. And why the Artificial Intelligence Act does not address the problem. It does not address the problem because the Artificial Intelligence Act, as you will see in a moment, include migration among the areas in which artificial intelligence can be used. And by including migration in the areas in which artificial intelligence can be used, is basically giving authorities the possibility to resort to this instrument with no further authorization, no specific authorization, because the Artificial Intelligence Act uses a broad expression, so it can those instruments can be used in all migration related context. The problem is therefore a problem of risk associated with such a use, and in that respect, the Artificial Intelligence Act include migration into the areas in which there is a risk associated with the use, a high risk associated with the use of those tools. But the white paper on artificial intelligence that was adopted by the Commission before the proposal of the Act was more concerned with the issue of trust, of citizens' trust towards public authorities. And in that sense, it was more aware probably than the Artificial Intelligence Act of the systemic problem that such a blanket authorization to use artificial intelligence can create. Now let's imagine a different scenario, a scenario in which a special authorization is needed to resort to artificial intelligence driven predictions in certain case. So far, the question has been addressed by the UK Information Commissioner Office in 2020, and the UK Information Commissioner Office, by interpreting Article 22, of the GDPR that I mentioned before said that whenever a law confers a certain power to public authorities, it's then a matter of public authorities' choice whether to resort or not to automated decisions, whether to resort or not to artificial intelligence tools. So so far, the spatial authorization has not been accepted as a principle. What would imply to have a spatial authorization? It would imply that either national parliaments or EU institutions should authorize case by case the use of artificial intelligence tools in certain areas. Of course, this is a complication of the current scenarios. This is a complication of the procedures that have been so far envisioned by the European Union institutions, but these at the same time would increase the level of responsibility of public actors as far as artificial intelligence tools are concerned. So this is an alternative scenarios that we can think of as a scenario that is more protective of fundamental rights, but at the same time is much more, it's politically much more complicated. Also, if we take into consideration the mechanism of decision making at the European Union level. So if we move to from the arguments that justify the use of artificial intelligence tools to fundamental rights concerns, we can see that there are at least 3 different types of concerns that in a way are counter arguments to the arguments presented before that would justify the use of artificial intelligence tools. First of all, the first problem is the obvious violation of fundamental rights, including the right to privacy, and especially data protection, and the right not to be subjected to automated decisions. Those are concerns that in the context of prediction of migratory flows are maybe less immediate to grasp, but they can still be relevant if we consider how certain tools operate. As you may remember, I told you before, some of those tools only concern open source data. So they would see whether there is a risk of a certain political change in a country, whether there was a climate change issue. And these, of course, are less impactful on fundamental rights. But some of those tools also use qualitative data. They also reach out to migrants, they talk to people, they try to understand their lifetime story. And in that sense, these can pose a risk of, these kind of tools can pose a risk of violation of fundamental rights. Again, we can appreciate the violations only if we exactly know how those tools work, which is not always the case. The second problem is the direct or indirect discrimination that we can have due to the implicit biases incorporated into the algorithm, or due to the subsequent appreciation of data that is made by a human being. The problem of indirect discrimination has been extensively discussed by the scholarship. Again, it seems to be less obvious in the case of predictions of flaws, because those predictions generally talk about and concern the general data. They do not concern, or they do not necessarily concern individuals, but we can have a systemic risk of discrimination. We can have a situation in which we assume that people from a certain country, just because they come from that country, can pose a risk, or their arrival can be disruptive for a political community. The third concern is particularly related to the right to asylum, because the main risk of those instruments, and which is what I want to concentrate the following discussion, is a systemic risk. The risk that states will simply react by adopting a policy of no arrival, strengthening border controls, and simply deny asylum request. Also, to give a message to those migrants not to approach their country again. So the main risk that is associated with prediction is actually a systemic risk. What, for example, Professor Carammia has called a political risk that is internal to the country where, or to the countries where predictions have been made. And the systemic risk is the risk of reducing simply protection for migrants as a whole, and simply reduce the arrival to the point of adopting a policy of no arrival at all. Now, considering the risk, such a risk, what is that the European Union Artificial Intelligence Act is doing? Well, not much. In what sense? Title 3, Article 6 of the Artificial Intelligence Act regulates high risk artificial intelligence system. The whole act, as you may know, is based on the logic of risk management, and they consider high risk those systems that create an adverse impact on people's safety and on their fundamental rights. Now, migration and border control management falls within this high risk. There is this category of high risk, but at the same time, this does not imply that those systems cannot be used. They simply imply that the regulation should be more attentive of the associated risk. But there is no actual implication in terms of resorting to those tools. What would be the alternative state of the situation? It would be to include migration and external border management within the unacceptable risk that are associated with artificial intelligence system. So those risks that suggested the European Union institution to simply ban certain forms of artificial intelligence. You can see here a list of those activities, those tools that the European Union has considered to be unacceptable, which means that the level of risk is just too high, and so they are banned. And that's why I was telling you at the beginning that iBorder.
Which number be piece official number?
I think someone has the audio on. Can you please check if you're okay? Thank you. So those are examples in which the EU has adopted a policy of no use because the risk is considered unacceptable. And as I was saying, iBorder, which is the tool that would identify emotions of people and would then try to understand whether someone is lying about his or her status as asylum seeker, for example, has been considered too controversial and therefore is not used by the European Union institutions are claiming that they do not use those systems. So there are many NGOs and civil societies associations that actually have lobbied the European Union institution to try to include migration in those lists of unacceptable tools. This has been discussed by the European Union Parliament that has acknowledged the problem, but so far this stance has not been accepted. So migration is today, as for today, a context in which it is considered high risk but not unacceptable risk to use those tools. So let's try to concentrate more specifically on what I have called the systemic concerns or the political risk associated with the use of migration, which means to concentrate not much on the problem of the individual fundamental rights implication, but on the more general problem of on the wider, let's say, implications of those uses for the political community as a whole, which also imply to take into consideration that the debate on artificial intelligence and migration can take place in context where states also employs a high level of populist rhetoric. And let's imagine an example in which we have an algorithm that can predict the likelihood that a migrant would face torture or inhuman and degrading treatment if they are sent back in their country of origin. And let's imagine that these algorithm settings consider the safety of the country of origin on the basis of a number of features derived from decisions made by competent authorities in the past. Now, in this case, we would have a number that estimate the people that, if expelled, if sent back to their country of origin, would face torture or inhuman and degrading treatment. Now, we can use this element, this piece of information, which is not a prediction of flaws, but we can use this piece of information and we can combine this piece of information with the data concerning the overall flaws of people. In what sense? We can imagine a context in which, within public debate, we also have those kind of information. We do not only know the number of people that will arrive at a certain point in time in a country, but we will also know the number of people that, if denied entry, will face inhuman or degrading treatment or even torture if they are sent back. In this way, the information concerning their arrival is combined with another information that concerns the fundamental rights impact of the arrival. This way of seeing the problem compels us to understand the problem of knowledge about migration flows as a more general problem of understanding the risks and the potentials of migration. So if we imagine such a scenario, we would match what we know about the flaws with what we know about the situation in which that flaw is not there, will not arrive, because we are preventing the flaws from arriving. This is a way of thinking of the problem of migration flaws that goes beyond the idea, is this useful or not, what this is actually, what is the implication of this particular type of information in the public debate. And we try to address the population awareness of what is a migration flows, what are the implications for human lives of migration flows. So we can imagine a different scenario, a scenario in which we have an open public debate on the use of data concerning migration that are fed into an algorithm and artificial intelligence tools. And we can imagine a situation in which we discuss the use of data, and this becomes a platform for to open a discussion. This has two major implications. One is that we can imagine a situation in which it's possible to actually counter profiling the artificial intelligence, and I am here coming back to the issue of replicability of data. We can imagine a situation in which all artificial intelligence tools are transparent. So we can actually access the question that is asked to the artificial intelligence, and we can actually understand the data that are fed into the artificial intelligence tools. And we can imagine a situation in which at least a certain number of people in the society, of course not everybody, is able to replicate those data and to understand whether there was biases, whether there are implicit discrimination that are imbued in those data, and so on and so forth. And we can also imagine a situation in which we have competitive tools that address the same issue. And we can imagine a situation in which we ask public authorities to impose a certain form of competition on artificial intelligence tools. I am using here a concept that has been elaborated by a legal scholar, Hildebrand, that has studied the use of artificial intelligence in many domains. She has called for an agonistic machine learning model, a context in which the law regulates the use of artificial intelligence tools by requiring those tools to be in competitions with one another, so that for the public authorities, the task would not be to take one single data, one single result stemming from one of those tools, but to combine data stemming from different tools and to arrive at decisions that are more rational and less emotional. If you read the scholarship on this topic, you will see that social scientists claim that the whole point with using artificial intelligence tools in migration is to reduce the number of decisions that are taken in emergency context, or the number of decisions taken out of a certain emotional reaction to a shock or to an emergency that prompts a huge number of people to move from one country to another. So this is an alternative scenario, an alternative legal framework, which is not in place right now, but that we can imagine would be a competitive, let's say, model of governance for artificial intelligence in the context of migration. What would this model imply in very briefly, so that we can move to the conclusion? This model implies that we can authorize the use of artificial intelligence tools in the context of migration only if three conditions are met. If people are able to understand the issue delegated to the artificial intelligence, if people can control and select issues that are delegated to artificial intelligence. And by people in this context, I mean the political process, so parliaments, either the domestic parliaments or the European Union institutions, meaning the parliament and the council. And three, if people can actually challenge the decision delegated to the artificial intelligence, how they are supposed to challenge these with the tools that I have mentioned before, with the possibility to access those data, with the possibility also to replicate those data. Now, one very easy, let's say, counter argument here is, to what extent can we expect people to be so involved so that they can actually understand what's going on, ask themselves questions on what's going on, and even challenge what's going on? Because this would imply that people have a certain cultural cognition of artificial intelligence tools, which means a minimum level of technological education that would help them to make sense of this reality. But I actually think that we can find these principles somehow hidden in the European Union legal framework. If you look at the European Union strategy on artificial intelligence, the education, the digital education, the technological education is considered as a primary concern of the European Union in light of the impact of artificial intelligence on social dynamics. So the European Union is basically saying, since artificial intelligence will become every day the issue of everyday life for European people, since they will have to confront with data elaborated by artificial intelligence on a daily basis, we should be aware of the problem, and we should promote a technological education. So it seems like a kind of utopian model, the one that I am suggesting, but actually, if you read carefully the European Union legal framework, we can find some traces of those models in the secondary legal instrument of the Union. So this model for AI governance in the context of migration that I am suggesting is based basically on the principle of transparency of decisions, but more importantly is based on the recognition of the need for political community to understand the use of those systems, to be able to discuss and to challenge the results that those systems create. And I will stop here and, as suggested, and leave the rest of time for discussion.
Questions? Online, questions online. Camila, please.
So thank you very much. Thank you, Professor. It was an extremely interesting lecture. And I would like to focus on the concept of appropriateness, because I think we can all agree on that AI in one way or another, but changes this concept also. What is appropriate measure? What are the criteria to define whether an instrument is appropriate or not? And who defines actually in whose hands is the decision of appropriateness? So you told that there is no current, no special authorization is needed, but you mentioned as well the possibility, let's say, to give the decision to national parliaments or to EU institutions. If I get it correctly, also I would add to this scheme of decision makers also maybe national data protection officers could be also. So if you could just provide your own insights on appropriateness in light of AI, so for AI instruments, AI-driven instruments, and also for, in your opinion, who should decide on their use. Thank you.
Thank you. Let's collect a couple of more questions and then, okay, there is Tatiana online and then I will give you the floor here in the room. Tatiana, please.
Yes, thank you. Yes, I'm working on, putting the microphone on. Okay, so thank you. It was a very interesting presentation. There are, of course, some questions in the chat when you have time to look over them. What I wanted to ask was, I think it's also building on the question that has just been addressed to you, on the level of appropriateness and also on the level of the general inequity of technological inequalities, because you were talking about consent and about understanding. I do not think that even with the current framework, the current asylum and migration framework, the issues of understanding and consent have been resolved. So it's a problem that exists even without involving AI and automated decision-making processing. So how would you address this with adding technology on top of already existing issues? Thank you.
Many thanks, Tatiana. Here from. Okay, let's finish then online and then we start from the room. Okay. Anna Smolinska, I guess there is a question written down in the chat. Anna, do you want to?
Yes, no, I was, thank you for giving me the floor. I was just wondering because you mentioned that there were lobbying efforts to include the migration in the list of areas where AI tools would be banned. And I know that the official position of the parliament for the trialogue negotiations, it has been adopted recently. And I was wondering whether this is part of the parliament position or whether it was, lost in the negotiations of MEPs. Thank you.
Thank you, Anna. Then Graziella for the first set of answers.
Okay, so thank you all for those questions. They are all very relevant to me. Concerning who decides about the appropriateness of measures. So I am a constitutional lawyer from, so I tend to trust, or I want to trust parliaments. Or, as you said, independent authorities where they exist almost everywhere now in Europe. The point here is that for now, the model is the model of a blanket authorization. So you can use artificial intelligence if you have a power to regulate, to manage a certain area, then you can use the most appropriate means you think for that area. This has been the approach that was the initial approach also with the Artificial Intelligence Act, as I will specify in a moment. in addressing the question of Anna, this has been understood as a major flaw of the approach and only partially corrected. So I think that in my view, the best approach would be to leave the issue of migration outside the Artificial Intelligence Act and to dedicate to the issue of migration a separated piece of legislation. And so to answer the question of who decides, I would say the European Union institutions, meaning the Parliament with the Council, with the usual procedures that also involves member states, but in a separate context, not in the context of the Artificial Intelligence Act as a whole, because this would increase the level of details that you can actually have on the appropriateness of use of certain tools as opposed to others. And to clarify my point here, I will connect with the question asked by Anna. So Anna, you are right that the Parliament has expressed a position on the issue, but the Parliament has said that they do not want the profiling tools to be included in the Artificial Intelligence Act. So the profiling tools will be banned. They are included in what I have mentioned before, in those tools that are considered to be too highly risky and so unacceptable risk for the European institution. But this was the result precisely of a lobbying exercise by especially a civic platform that is called Access Now. You may be aware of that, and which insisted a lot on the problem of fundamental rights of migrants. They would have been profiled. So this was excluded, and the European Union, the Parliament in particular, and some MPs have been quite clear on that point. But flaws, prediction of flaws, no, I don't think there is any room for banning the prediction of flaws. It's just too much, it's just too much there. It's just too used. It's just so common, and it's also linked with what states were doing in the past with forecasting without even artificial intelligence tools. So I don't see a way in which there would be a compromise solution on flaws. And the other question concerning inequality and inequities are already there concerning migration in general, let alone the artificial intelligence tools. True, but I deeply think the problem is a problem of pluralism in the discussion of migration issues. The problem of letting people know the reality, which is, I guess, what Professor Carammia was saying before about the role of knowledge, and to spread knowledge about things, which is what those tools can do. And then a separate issue is how we use the knowledge. But my first impression when I started to study this topic is that actually, if we dig a little bit more on the reality, and if we know numbers, we may change our views. Of course, this in a way imply that politicians are willing to discuss and use those numbers in a honest way, which is not to be taken for granted everywhere. But I believe that foster a public discussion on the reality of migration is what is missing now.
Many thanks, Graziella. So let's collect some questions from the room. Please recall your name when you start.
Thank you, Prof. My name is Chinedu. Thank you, Prof, for the presentation. And my question is concerning what the Parliament is doing about the cost dynamics of AI. You've shed so much light on the social dynamics and how the Parliament has pointed its high risk in terms of people's safety. But I am asking, what's the Parliament doing in terms of the cost of having this AI? First, the environmental cost. Secondly, the financial cost to the end user. Currently, it costs about 10 euros per month to access some certain AI and cost about 37,000 euros to acquire a unit of a particular AI that's also being used in these talked technologies. Secondly, thirdly, the cost to produce microchips that powers this AI burdens more on water resources. So why the focus on these social dynamics? What's the Parliament doing about the inherent cost as regards to the background risk associated with production, manufacturing, and assembling of these AI components before assessing its use? I make this question bearing in mind the recent legislation about ecocide. And as a result of interest in knowing how this ecocide is contributing to climate change, I came across the fact that AI uses a lot of water and adds a lot of CO2. And if there is no regulation on its use, what then would be the fate of its ecocide law that is coming on board? Thank you.
Questions? No other questions from the room, Graziella, so you can answer these and then we can wrap it up. Thank you.
Yes, I don't think that the European Union Parliament is doing much on that issue. But I think there is a reason for that. First of all, some of those tools, some of those artificial intelligence tools that I have mentioned are not tools, are all funded by the European Union, true, but they are all funded through specific budget plan. So one has been funded within the European Union Asylum Support Office, and so it's within the budget. And the other one has been funded by the European Commission through a line of funding that is open to all types of research in social science. So I think that the issue of financial cost is absorbed by the fact that those are tools adopted within a certain budgetary plan that already existed and that can be used for that. So it doesn't raise that kind of concern. For other type of costs, you mentioned the environmental costs. I think this is a political decision. And the point here is that it's clear that European Union institutions and countries all over the world think that prediction of migratory flows is very relevant to at least measure the domestic impact of migration. This is not always done for good reasons, to improve reception or to understand better the logic of demographic transformation. Sometimes it's done to just try to appease domestic social tensions, or to tame some types of political disagreement. But I think that it's clear that it is considered an indispensable tool for policy choices. So I don't see the European Union Parliament even trying to address the opportunity of resorting to this tool. And I agree with you that there are many costs associated with that. And this is the reason why I think that the discussion should be more open. And this is also the reason why I think that the use of those tools in the context of migration would have needed a specific legislative act by the European Union. But I don't really see those costs being included in the discussion.
Many thanks, Graziella. I think we can close it here. Thank you so much for being with us for this hour and a half. I think we can reconvene for the afternoon. Thank you.
Thank you all. Thanks.
Well deserved. We can reconvene in the afternoon for the training session at 2:30. Ok. Break time. Grazie, Graziella. Ci vediamo presto.
Ciao, ciao, ciao.
Ciao.